Conservation District, acting by and through its Colorado River water projects enterprise.
Yeah, Madam President, if I may, under item number 1 on the agenda, review meeting agenda objectives, I would just ask for one minor modification to the agenda. And that is to under 12H is a service anniversary. DK Kanzer is not present today. He's on leave, and we would just ask that we postpone that item. So other than that, we will think the agenda stands as presented.
All right, anything else on the agenda? Any other changes? All right, and then we have a motion to accept the agenda as modified.
So moved.
Moved by Roper.
Aye.
Any opposed? All right, next up is presentation and report of directors' credentials,
Okay.
and I'll turn that over to Andy.
Thank you. Madam President, we have received and reviewed the credentials for directors from Delta, Eagle, Grand, Hinsdale, and Summit County. We're still scratching our heads on the Hinsdale one, but I'm just kidding. Totally. Very thankful that everybody has come back. We mentioned earlier at our workshop that we have a new member from Summit County who apparently old is the new again, Director Martinez. And just want to say the credentials are all in order, and we believe that there's no action that should be made or needed, but just wanted to make sure that you are aware of that. Traditionally, when we have a new board member, the board members introduce themselves to the new board member. So happy to run around the room and also introduce staff if that's something.
All right, Gary, so tell us who you are and.
Yuri Martinez, resident of Summit County for many years. And I really didn't leave Summit County. I have a place in Denver. I was Breckenridge Town Manager for 15 years. Seemed like a sentence. It was from 85 to 2000. Did some work in the private sector with East West Partners, a big Eagle County, Harry Frampton and those guys. Was the county manager in Summit County from 2007 to through 2016, and then tried to retire. Didn't work, so I've been running around. And got a call recently from the commissioners wanting to know if I was interested in going back on the board. I think they'd had a long discussion about who they should try to get on at this time for this board, and I was happy to do it. So here I am, happy to be back.
Welcome and welcome back. All right, and let's go around the room and just introduce ourselves and what county you're from.
I'm Francie Jacober. I'm a commissioner from Pitkin County, but I live right outside of Carbondale. In Pitkin County, barely.
I'm Steve Beckley with Garfield County.
Sonia Travis, Gunnison County.
Marty Cotton. I'm sorry. I thought it was just,
Oh, yes.
I'm with him. Mark Catlin. We were on the board together.
Yes.
Kathy Chandler Henry, Eagle County.
Mark Rober from Delta County.
Mike Richard, Grand County.
Al Vandenbrink, Rio Blanco County.
Doug Mutter, Route County, and we were on the board together
You
too.
bet.
And too, yeah.
Yes. Eric Dennison from Uray County.
Great, and let's start in the staff. Go around, Melissa, you want to start?
Hi, I'm Melissa Wills. I run our community funding partnership, our new grant program. Amy Moyer, Director of Strategic Partnerships.
Brendan Langenheisen, Director of Technical Advocacy.
Matt Abusi, Communications Director. Sam Callahan, Water Resources Specialist.
Zane Kessler, Government Relations Director.
Laura Nichols, paralegal for Peter, Jason, and Bruce.
Andy Mueller, General Manager.
Now you can.
Thank you.
Peter Fleming, General Counsel.
Good seeing you two guys.
Yeah, both are back there. Good to have
Jason?
Jason Turner, Deputy General Counsel.
Audrey, Chief of Operations.
Bruce Walters, Associate Counsel.
Stephanie Moore, Executive Assistant.
Raquel Flinker, Senior Water Resources.
Mike Causey, Director of Asset Management / Chief Engineer.
Coming on the the staff when I left, so. Yeah, right. Really good.
And I think you know our audience member as well, Dave Merritt.
Dave Merritt, Boy Scout Troop 225.
And Scott, you want to introduce yourself to?
I know Barry for a long, long time.
All right.
Great guy.
The band's back together. Welcome, Gary, and congratulations to all of us who were reappointed as well. And now to the exciting part of the agenda, election of board officers for 2025. And we will start with election of president, and then I will turn the rest of the meeting over to the president. So do we have any nominations for president?
Second. I'd also move nominations cease.
But do we also move it?
The nomination cease.
All right, so we have a nomination for Mark Catlin by
Second, I'd second.
Director Winery and second by Logan Beckley and Munger. And I will ask if there are any other nominations. All right, then we will close nominations. And would you like to say a few words, Mr. Catlin? Are you willing to accept the nomination, and if elected, will you serve?
I'd certainly accept the nomination. I think I've told some of you before, but in my mind, this has been the most important job I've had because of the future of the Colorado River. And even though with the new elected position, I think we're going to be able to focus on this too. This ties right into the district that I represent in the Senate, and it's been a passion of mine for a long time. So I'm ready. Let's go find out. Thank you.
Okay. So we do have paper ballots, but I would suggest that we vote by acclamation if that's acceptable. Okay, all those in favor of Mark Catlin as the right, Mr. Hubble.
No.
Oh, yeah, you're changing.
I don't want to sit by him.
That's part of being in the principal's office.
Yeah, well,
Why do you think Robert's over here?
think we're over here. Well, yeah, you can always ask the attorney, do you think we should? So, all right, guys. Never gonna sit here and speak. Let me see.
First order of
First order of
business.
business is vice president. So I'll open the nominations for vice president.
I nominate the distinguished gentleman to my right, Mr. Richard as vice president.
Okay. Are there any other? Do we have a second? No seconds.
Second.
Then you guys want to vote? I'll call for an affirmation. All those in favor, Mr. Richard? Yeah.
Aye.
Welcome to. All right.
Take your name tag with you.
Oh, you have to change seats too.
Yeah.
On the appointment of committees, Mr. President has reviewed the comments submitted by the board. If you remember, we asked you all for your input. Those of you who didn't provide any input, you have no grounds for complaining as to which committee you were assigned. But if you do, take it up with Mr. Catlin, not me. We will distribute the list of committee membership here, except I want to read into the record for the information and outreach. Matt, what time is that meeting tomorrow morning?
7:30.
7:30 in this room. Breakfast will be served, but members of the Information and Outreach Committee are asked to be here for that meeting. All board members are welcome to any committee meeting, so you're all welcome at 7:30. The meeting, our general meeting starts at 8:30. But the members appointed by President Catlin for the Information and Outreach are Director Jacober, Director Chandler Henry, Director Hazard, Director Chavez, and Director Gray. And that would be the makeup of the Information and Outreach Committee. As I said, we'll get you the list of other committee members here before the end of the day. Just as a reminder, there's an investment committee, a litigation committee, a water supply projects committee, and the executive committee. The executive committee has a rotating membership, and it is run by basin and then by county within the basin, dependent upon who was going to get elected. So we will get those out as well by the end of the day. Any questions on that? Okay.
All right. Adoption of resolution for outgoing directors.
We only had one, that would be Taylor Hawes of Summit County, who stepped down, and we have a proposed resolution in your packet under item number 5. It would require a motion, a second, and a vote.
So moved. Second.
Okay, we've got a motion and a second. For
Motion by Winery, second by Vandenbrink.
You want me to call that
If
out?
you don't mind, it helps the record.
Okay, good enough. Winery made the motion and Longer make the second. Oh, Vandenbrink made the second. So all those in favor of the adoption of resolution for Taylor Hawes, say aye.
Aye.
All those opposed? Same sign. That passes. Okay. On to the consent agenda.
Consent agenda items 6A through E. Unless somebody would like one of those items removed, we would ask for a motion to approve the consent agenda and the second, followed by a vote.
A motion made by Ms. Chavez, second by Gary Dennison. All those in favor?
Aye.
All those. All right. Pass the consent agenda.
Moving on to general counsel's report.
Thank you. Mr. President, I'd make a recommendation that the board convene into executive session pursuant to CRS section 24-6-402 paren 4B and E to discuss the items listed on today's agenda under tab 7A.
So we need a motion to move into executive session.
So moved.
Second. Who made the motion? Dennison made the motion. Winery made the second. All those in favor?
Aye.
All right.
Thank you, Mr. President and board. I would state for the record that the subjects and the matters to be discussed in executive session will constitute attorney-client communications for which no further recording needs to be made.
You need a motion to do that?
No, sir.
You just pull us out.
Okay. We're now out of executive session and back into the public session. The general counsel report in public session.
Wait until we get the system recording again and anybody that's in the waiting room back.
It is recording
It is
and
recording.
the waiting room is empty.
Yes. So dokes. Well, then we're all ready. Mr. President, if you would like, I could give a summary of the discussion during executive session.
Would you please?
Yes, during the executive session of the board's meeting today, the board discussed with and received legal advice from counsel on the items listed under agenda tab 7A. I would note for the record that Director Jacober did not participate in the discussion of agenda item 7A1. And Bruce Walters did not participate in the discussion on agenda item 7A. There was one potential item that the staff thought would be prudent for action. That was discussed during the executive session. Would you like me to make a recommendation, Mr. President?
Would you please?
I would recommend that the board adopt a motion authorizing general counsel to retain Robert Fishman as special counsel on pellet matters. So moved.
Monger second. All those in favor?
Aye.
All those opposed? Motion passed.
Thank you. Next up is, I'm gonna turn it over to Jason for discussion on the Kobe Water Authority proposed action item.
Thanks, Peter. This discussion's on page 123 of your digital packet. And I'm gonna try to condense 40+ years of history into a very short amount of time. So what we're discussing here is an amendment to the contract that created the Kobe Water Authority. The Kobe Water Authority was established to manage the Kobe project, which is a project constructed just outside of Quebec that is a pump station and pipeline that takes water out of the Colorado River and can deliver it for both agricultural and industrial needs. This project actually started back in the mid-80s. The River District appropriated these water rights and held them in trust for the Bluestone District. Chevron, well, originally Getty, came in and was interested in developing that project. So for a number of years, they conducted diligence on the project and paid a lease fee to what was then known as the Bluestone Committee, which was made up of 2 members from the River District and 2 members from the Bluestone Water Conservancy District. That went on for a number of years. They actually constructed the intake for the pump station. And then at the upper end, they constructed about 1 mile of pipe. And so the project was the original intent of the project was to take water out of the Colorado River, deliver it to Roan Creek above the 2 most senior rights on Roan Creek, which would take that call off, free water farther upstream. So then the industrial users up there would then eventually pump it over to a reservoir basin. When I got to the district, and by this time Chevron had taken over all of Getty's assets in that area. And by the time I got to the River District in 2008, Chevron was thinking to themselves, why are we still leasing this water? We have a whole portfolio of our own water rights. We don't need this. So when I got here in 2008, we were trying to unravel that deal. In the process of unraveling that deal, we got approached by another energy company that said, hey, we'd like to construct this project. And so they did, and they put in, it's roughly 6 miles of pipeline, and the project still operates similar to its original intent. The reservoir was never constructed, but it can still deliver water up to Roan Creek above the 2 most senior calling rights. When the project was constructed, we also put a facility up at the top where water could be. We initially had planned on putting a pond up there to store water. It's now a series of water tanks up there, which allow for trucks to come and fill and haul water from there. It also allows for relay pumps to be connected so that we can pump it up to that storage facility, and then it can be pumped farther up on the mesa. When that project was finished with its construction, it was to be conveyed over to the districts. At that time, we had the Bluestone Water Committee, which wasn't a legal entity. So in 2015, pursuant to statute, we formed the Kobe Water Authority. And the Kobe Water Authority, for all intents and purposes, operates much like the management committee did to kind of maintain and operate that project, but it's a legal entity. And it's important to remember that it is a separate legal entity from either one of the districts. Again, it's represented by 2 members from the Bluestone Water Conservancy District and 2 members from the River District. Director McGinnis is on that board, as well as former Director Merritt, who was here earlier. The board appointed those folks, and I think the reason that they kept Director Merritt on that board was because he has a very long-running history with that project. In fact, it was one of the first projects he worked on, as he mentioned, when he got to the district 40 years ago. So the project, or the water authority, basically gets all of its funding from a long-term industrial lease, and then some of the residuals from the money that Getty and Chevron had contributed over the years. We were recently approached by the Bluestone District, the authority was, requesting perhaps whether they would consider contributing some funds to their operating budget, the Bluestone District's operating budget. It's a fairly large district, but it's got a lot of federal lands within it. It has a very small mill levy and a very small tax base. They are finding they are in financial straits, especially on accounting, because just like every district, they need to file taxes and they need an accountant to do that. They're not talking about a huge sum of money. I think they said that $5,000 would tie them over for the next 3 years. And I should note that the Water Authority gets legal representation from myself and Bluestone's attorney. So Ryan and I work very closely. I mean, technically I represent our 2 board members. He represents their 2 board members, but I would say, and I'd ask Director McGinnis to chime in here, but I think that board, those 4 people have worked very well together over the years. And so that proposal came in. Ryan and I started looking at the contract that formed the authority and asking ourselves the question, does the authority have the ability to make that contribution as a gift to the Bluestone Conservancy District? I think within the current contract, I think there are provisions that would allow that to happen. But there's also a provision in the statute that established the Water Authority that allows for exactly this to happen. That the authority may contribute funds to one of the member entities. And so what we're requesting here is that we amend that contract to include that provision from the statute. And I've quoted the statute in your board materials, and I've also, there's a link to a red line of the amendment that we're proposing so that you can see all the changes. We made some other slight tweaks in there just to reflect sort of what's happened since 2015 in terms of us making certain of those water rights absolute for various purposes, et cetera. But the primary provision would be to allow specifically the authority to provide revenues to the Bluestone District to assist with their operating costs. Like I said, this is specifically called out and allowed for in the statute. And the only reason we're really coming back to this board is because this board and the Bluestone District initially entered this contract to form the authority. So we think it's your purview on whether the contract can be amended for those purposes. So I'm happy to answer any questions.
What is the water ultimately used for?
So it is used for, we have a long-term industrial contract. We also make deliveries to agricultural users on Roan Creek. And again, when that water is pumped up there to free up the call, it frees it up for those industrial users, but also agricultural users, especially on the tributaries.
So why can't they do it now? Because the contract says it can't, or we're just clarifying it.
I want it, that's the purpose. I wanted to clarify.
Just making sure that we're, okay, yeah, so I don't have a problem with that, but, and again, it's not our money. We're just enabling it to come out of the authority. Otherwise, somebody's gonna help them do their, I mean, with their, yeah, so it's odd that they wouldn't have the ability in the first place.
Well, you know, I think the numbers we saw, you know, their mill levy brings in about $5,000 a year.
No, I understand that, but why they couldn't take money for the services that they providing and charge the authority for that and then use the money to pay the audit bill or whatever. So again, bells and whistles, yes, my question. Thank you.
Just one point of clarification and a question for Jason, but our time, Jason and Ian's time, other staff that helps out with the authority is reimbursed by the revenue of the authority. So we don't, you know, we're even on it.
Yeah, we're neutral.
Other than the time it takes, I mean, that time gets reimbursed, but the actual hours are spent doing that rather than something else. So that's not a huge amount of time. And then Jason, you said it's basically sort of belt and suspenders. The statute provides for this ability. It's not specific in the original contract creating the authority, but there wasn't anything that you recall in the creation of the authority that expressly prohibited this or contemplated, so it's,
No, I mean, it is one of the enumerated provisions of the powers of the authority. It just didn't end up in the original contract.
Scott?
Might add that this came up after Dave and I requested they donate $25,000 to the Shoshone. And subsequently another $25,000, which is big money for the authority. And then Crestone said, we can't pay anything, we're broke. So the board had no problem at all cross subsidizing. And like $5,000 over 3 years, that gives you an idea how much you're asking for. And none of their board gets paid, none of their, so it's a good cause, just like the Shoshone. And we felt we had the authority to do it without having to come here, but council, dot the i's and cross the t's. So we decided we better do it.
So do we need a motion? Is that what?
Yes, I would recommend that the board authorize the execution of the first amended contract establishing the Kobe Watch Authority.
Margaret moves staff recommendation.
Second, Chavez.
Second, Munger and Chavez second. Those in favor?
Aye.
Opposed? Motion pass.
Thank you very much.
thank you. The next item to take up is a potential action item. I'm going to ask Bruce to handle this regarding special counsel rates for 2025.
Thank you, Peter. Directing everyone's attention to page 124 or page 7 of the joint attorney report. As everyone knows, on occasion, the River District uses special counsel to assist with various legal matters that rest beyond the collective expertise of the 3 attorneys we have in-house. The River District's special counsel policy requires during those occasions that the board approve any retained special counsel, as well as any rate increases for retained special counsel. We've received 3 new rate schedules for 2025 for some of the River District's existing approved special counsel. To start at Carpenter Hanlon, 2025 rates for the 2 attorneys that have worked very closely with the River District over the last 2 years, Mr. Fosnot and Ms. Rosenthal, are $375 an hour and $350 per hour respectively for those 2. And at Dietz and Davis, the River District has worked with Carl Kumley on a number of matters over the last few years. His 2025 hourly rate has increased to $400. Each of these rates, I would note, reflect the respective firms' government discounts, which were provided as a courtesy to the River Districts. Considering the expertise of our special counsel, the current markets, we do believe that the 2025 rate increases are reasonable. And I would therefore recommend that the board approve those 2025 rates for the listed special counsel.
So have we received itemized billings from outside counsel?
Hourly.
For services
Yes,
rendered, detailed, itemized.
they're detailed.
Okay.
It could be more detailed at some points in time, but they are detailed sufficient that we review them. On occasion, it's been very rare, I've called, asked, but they're within the industry practice, I'll put that.
Just to maybe refresh the board's memory, Carl Kumley is a Public Utilities Commission expert. We have him on retainer.
Do we need a motion to approve this?
We do.
So moved.
Second.
Motion by Alden Vanderbrink and Stan Winery second. All those in favor?
Aye.
Those opposed? Motion passed.
Thank you. The next item that's on your agenda at least is the general counsel goals and objectives that I've provided. That's on page 124, I believe, of the PDF report. These reflect a discussion during my annual review back in October. I suspect that those might have to change a little bit given any future direction on the strategic plan. We'll adjust accordingly, but if you have any questions about what was listed there, happy to discuss. Otherwise, I don't have anything else. And unless the board has questions about anything else in the public report.
We are scheduled to take a break. I just want to point out, Peter, congratulations. He finished the executive session exactly on time, just finished the public session a little early. So,
I mean, if it were up to me, they'd all be like that.
okay, well,
too.
We have scheduled at 3:35, the CDPHE. We might try to see if the representative can dial in earlier. If she can't, I would suggest that we reconvene in hopefully in 15 minutes, 3:20, let's just say, and that we would, if we don't have CDPHE online, we'll take one of my items out of the general manager's report and go back to CDPHE when they're, if that works. Okay, adjourn for a break, not adjourn, but take a break.
Let's just take a look, folks.
Thank you.
You can think we-
I don't know.
Can't win with those.
Hey, guys.
All right, Ed. All right. Our next presentation was supposed to be in person by Annette Quill at the CDPHE. We appear to have had some communication mishaps with Ms. Quill. She's unable to be here on the West Slope in person. Filling in for her via remote connection is Kelly Morgan. And Ms. Morgan, I don't know if your camera, if you're capable of turning that camera on and talking to the board.
Yes.
Great. Oh, there we are. Sorry, just see you. Okay, excellent. Well, Kelly, thank you for coming. It's greatly appreciated. I just want to, as an introduction, I think the board is familiar with the fact that CDPHE, the legislature passed a bill to authorize CDPHE to create a dredge and fill permit process to not only fill the gap waters, but also Colorado's waters under a slightly more expansive definition. Our district has been engaged in the stakeholder process significantly, both through the legislature and now through their stakeholder process. Rebecca Breezemore, who is online but is sick and was kind enough not to come in person to get everybody else sick, has been our lead staff member on this water quality issue. But perhaps the best thing to do is just turn it over to Ms. Morgan to introduce herself and talk about where they are in the process and what they're doing. So thank you very much.
Yeah, thank you for the introduction. Thank you all for being willing to accommodate us. Can you see and hear me okay?
Oh, no. You got a bad echo.
Okay, let me just try something. Did that help with the echo at all?
Yeah, it's better.
Well, you're in a barrel, but it's
Yeah.
okay.
As good as we'll get? I can't hear anyone in the room, so let me just see.
Kelly, can you hear me?
Okay, any better?
Can you hear me now?
Yeah, perfect. Okay. Thank you. Just as I was saying, thank you for the opportunity to let me participate remotely. Something, of course, would go wrong right at the beginning, but I do really appreciate the opportunity and apologies that we weren't able to make it out there. I do prefer in-person meetings, so appreciate this isn't an ideal situation, but I'm happy to have the opportunity to share with you all some of what we've been doing and what we're planning on undertaking in these next several months. So feel free to chime in if you have questions at any point. There will be opportunity at the end for some questions. I do appreciate the introduction and just some background on your all's participation in the process. So I think just in the interest of keeping your attention and not reiterating what we've said, I probably will go through some of my slides early, but we're happy to also provide a slide deck for you so you have that for your reference. So just to give you some introductions, my name is Kelly Morgan. I'm with the Water Quality Control Division, and I manage our Clean Water Compliance and Enforcement section. As was mentioned, Annette Quill is also really taking a lead role on developing the regulation that's associated with this legislation. Annette's our senior policy advisor in the Water Quality Control Division. And then with us, not today, but Tessa Atkins from our comms team is also helping, and she's consolidating a lot of the feedback that we received thus far on the regulation. I also included just some contact information for folks that are associated with our commission that will be doing the rulemaking associated with this legislation. So just a quick overview. It sounds like most of you are familiar, so I won't read the slides, but essentially in May, the legislature passed House Bill 24-1379, which granted the Water Quality Control Commission and the Water Quality Control Division some authority to regulate dredge and fill activities associated with state waters that are no longer federally protected. This diagram kind of outlines where the state is filling the gap on protecting state waters following the Sackett decision. So essentially after that decision, which limited the scope of federal jurisdiction over dredge and fill activities in the state took action to that gap to ensure our state waters are protected, with the exception of some exemptions and exclusions, which I'll get into shortly. So wanted to kind of start off with some discussion on these exemptions and exclusions. Essentially, exemptions are related to activities associated with dredge and fill, and then I'm sorry. So we'll get then excluded waters are types of water features that are also excluded from requirement to obtain permit coverage for dredge and fill activities. So I think it's important here just to point out that the legislation identifies 13 exempted activities. You'll see some of these activities highlighted on your screen there in the green text are not federal exemptions, but they were activities that the legislature determined should be exempted. So there are essentially some Colorado-specific exemptions. So you can see here on your screen, one that I wanted to highlight is this exemption number 7. This is a really important one for agricultural and ranching activities, and a lot of time went into developing this with input from the agricultural community. So this particular exemption uses a federal exemption as its basis, but the scope is broader. And broader meaning how we define the terms construction and maintenance. Those are outlined in the bill if you want some further detail on what exactly they mean. But by way of example, irrigation ditches are defined in the bill. Irrigation ditches include head gates, so construction or maintenance of those head gates in state waters would not require coverage under our program. And then moving along to some additional exempted activities. Again, I'm not going to read these word for word, but the green text exempted activities were those that were added to the federal list of exemptions, and those were specifically related to Colorado and input that was received during the development of the legislation. And then moving along, again, based on kind of the federal framework, the legislation identifies some excluded water features, again, meaning that dredge and fill activities that occur in these types of water features do not need coverage under our program for dredge and fill activities. These excluded water features aren't linked to exemptions, so they stand alone. In other words, if you're discharging fill material in to these types of water features, no matter what type of activity you're undertaking, you are not required to obtain authorization from our division for that particular activity. And then again, some additional water features. One that I wanted to highlight here, number 11, prior converted cropland. This uses the 2020 Navigable Waters Protection Rule preamble, and this exclusions for prior converted cropland were really made at the request from the Colorado Department of Agriculture and other agricultural stakeholders. And so that's really how we kind of further refined the federal description of that excluded type of water feature. Did I see a question in the room or hear a question in the room? Okay.
I don't, no.
Okay, I'll keep moving along, but feel free to interrupt. And then just wanting to get into some of the implementation components. And so the House Bill 24-1379 directs our Water Quality Control Division to develop a dredge and fill authorization program. And that particular program will be housed in our compliance and enforcement section that I manage. So we will have a team dedicated to, providing guidance, answering questions, and also issuing authorizations under our rules. And then as another prong of the legislation, the legislation directs our Water Quality Control Commission to establish regulations for avoiding, minimizing, and mitigating the impacts of dredge and fill activities. And so we're currently in the process of that. And it sounds like some of you all have been engaged in the stakeholder process, which is great. And for those of you who aren't familiar with the difference between the division and the commission, is the commission is our rulemaking body, and they go through the whole stakeholder process and also help develop regulations, whether they be permitting or control regulations. And then I'm going to speak next to the dredge and fill authorization program. This is something that might be of interest to those of you who have been involved in the stakeholder process, because we've made some progress here as far as program implementation. So just as a little bit of a background, Colorado law prohibits any discharge of pollutants to state waters, and that includes dredge and fill activities. So in immediate response to the Sackett decision, the division implemented what we call our Clean Water Policy 17. And this policy allowed certain projects to proceed in the absence of a permitting program. So as long as these activities implemented protective measures and notified our division of the activity, they were allowed to proceed under that policy without the risk of enforcement. And that policy was in place until just very recently, until January 1st, 2025. So any project that occurred between 2023 and 2024 was allowed to operate under that enforcement discretion policy. And then kind of moving on to where we are today with program implementation is we are prepared to issue what we're calling temporary authorizations. This is an interim measure to, again, provide coverage and some more surety to project proponents. And of their coverage in the absence of a regulation. So this is kind of intended to fill the gap between January 1, 2025 and when the Regulation 87 becomes effective in 2026. So I wanted to share with you all just a quick snapshot of our new website. I'm going to give this a try and see if it works, but I will share this link with you. But this is our new website that describes who needs to obtain a temporary authorization, as well as how you obtain that temporary authorization. So a lot of these temporary authorizations are required for activities that obviously are occurring in waters that are no longer deemed waters of the United States. And these projects would also require compensatory mitigation, and I'll get into that in the next few slides, but just wanted to share this with you all. There's some information on what a notice of temporary authorization actually looks like. And essentially what the state of Colorado has done with these temporary authorizations is that we are recognizing the core permits for nationwide and regional general permits. We're essentially incorporating them by reference. And so our expectation is that a project proponent or owner and operator complies with the terms of that relevant nationwide or regional general permit, and that we're essentially authorizing the project to take place under those control measure provisions, terms and conditions that are in those U.S. Army Corps of Engineer permits. We did include some Colorado specific requirements, but nothing too involved. One I'll point out as I get into this, one example would be just the authority for our division to enter and inspect a project to determine compliance. Moving back to the slides, I'll share this again, these links with you after I'm done presenting, but wanted to share this with you. There's also some contact information down here. You'll notice if you click on this little button down here, contact information, we have a general email inbox. So if you have questions about a project or just the state rules and guidelines and program implementation, you're welcome to email that website. And then this also lists 2 of our staff that are undertaking this project alongside of me and our program. So they are another good resource for you all. And I kind of just hit on this a little bit, but essentially recognizing these nationwide and regional general permits. And part of the rationale behind this was that we wanted to provide folks some consistency and some familiarity with what you may or may not have been used to working under the federal framework, and also to provide some clarity for project proponents on how to comply with this authorization. In the absence of a permitting program, we needed something to fill the gap, and Clean Water Policy 17 wasn't intended to be a long-standing policy. So, hopefully that provides some consistency for those of you who are familiar working under the federal framework. Temporary authorizations will be effective for a period of 2 years, and again, really intended to fill the gap in time between when we could pass a regulation and to allow these projects to move forward without the risk of formal enforcement from the state. Some key components of these temporary authorizations that you must submit a complete application in advance of the project. We do have time control goals associated with how long the division has to review an application, which is why we are asking folks to submit a complete application prior to the initiation of our review. So the bill does require us to provide notification to an applicant within 45 days of receiving a complete application. So we are positioned to meet that time control goal as long as we have a complete application. I mentioned the authority to enter and inspect a project. And then last, that some of you might be familiar if you're working with are under the terms of our construction general permit with best management practices, which we now consider control measures. Purpose of implementing those control measures is to minimize both temporary and permanent adverse effects to state waters. We will be developing, as we move forward, we will be developing guidance on, effective control measures and ways that you can kind of minimize your impact. So look forward to that over the course of this next year. One addition to or change from Clean Water Policy 17 is that these temporary authorizations will require compensatory mitigation if that's relevant and applicable to your project. But the intent of including compensatory mitigation is to offset any unavoidable impacts that remain or occur as a result of your project. But just to note here, there are these unavoidable impact thresholds. So there's one for wetlands. If your project were to exceed or permanently impact more than 0.1 acre of wetlands, that you would be required to undertake compensatory mitigation. Same applies to streams, just a different acreage level. And so this, I know this slide is a little wordy, but just to kind of summarize that when you apply for a temporary authorization, we're asking folks to basically inform us if you believe compensatory mitigation is required, and if that's the case, how you intend to undertake that compensatory mitigation. I'll get into that in just a moment. And then based on your application, if our division determines that compensatory mitigation is required, we will include that in your temporary authorization. Again, we are utilizing tools that the Corps utilizes to determine the amount of compensatory mitigation, again, in an effort to provide some consistency for you all who are familiar with these types of projects. Compensatory mitigation requirements for streams. Again, I just went over this, so I'll just briefly demonstrate this slide. But as I mentioned, as far as determining the level of impact that your project might have, we are directing folks to use the Colorado Stream Quantification Tool. Some of you might know that as the CSQT. And then using that for streams can also be utilized for wetlands to determine your impact. One last thing, as far as authorizations that I'll mention, the bill also directs us to develop a general authorization for isolated state waters. So we are currently developing that authorization, which will be effective for 5 years. The goal is to have that authorization available for public notice and comment in the spring of 2025. So hopefully by the end of March, we'll have something out to share for you all to review and comment on. And then getting into development of Regulation 87, it sounds like some of you have been engaged in the stakeholder process, which is great. We really welcome, diverse inputs and, thoughts on how we can improve, mainly on the federal program, and make it make sense for Colorado. So essentially, the bill requires the regulation to be at least as stringent as the U.S. Army Corps of Engineers requirements. Doesn't expand the scope, but what it does is just essentially close the gap for protecting state waters that exist as a result of the SACIT decision. One thing I do want to point out here under these program rules is that the division may adopt some clarification to those exemptions and exclusions that I mentioned earlier on in the presentation. So those won't change, but certainly will be encouraging folks, if you would like to see some clarification there. We would encourage folks to provide that input in their stakeholder feedback. The other item or achievement that we're hoping to gain out of development of Regulation 87 are some rules related to individual authorization. So these might be for larger water supply projects or reservoir construction type of projects that are occurring in state waters. And then again, or last, the regulation needs to also provide rules on compensatory mitigation. And we are welcome to input here, especially for those of you who are experienced with compensatory mitigation. We're really looking for your input and feedback on how we can better improve guidance there or the rules surrounding compensatory mitigation. And just kind of a bit overview, we do have a draft regulation 87 developed that we shared with stakeholders in the beginning of December. We asked for some initial feedback in January, so we are consolidating all of those comments and that feedback so that we can work collectively as a group to develop and further refine the ideas and thoughts that are in that draft regulation currently. Some links here again, we'll share these slides with you all so you have the links handy, but there's opportunities for you all to review the draft regulation and then some notes that the division made on that draft regulation, which those notes kind of explain the basis for some of the terms that we are proposing to include in regulation 87. Here's the development schedule. Essentially, we proposed that draft regulation in December. Are working through the commission process. There are certain deadlines, namely this second to last bullet here is that the formal rulemaking process will begin in August 2025. And so that's where, there's some more rules and time control guides that our commission is responsible for. So they will help walk through that process. And just as a note, for all of our stakeholder meetings, we do walk through that process. So if you would like some more specifics there, I encourage you to participate, at least in the next stakeholder meeting, just to familiarize yourself with that. We are holding monthly stakeholder meetings, again, seeking feedback on the draft regulation throughout all of these stakeholder meetings. We will be providing updated drafts of the regulation based on comments and feedback that we receive through the stakeholder process. Again, after each one of these stakeholder meetings, we'll be seeking feedback from folks. So you may or may not have comments after each stakeholder meeting, but you will have the opportunity to comment as you see fit. And so that is a kind of a quick overview. Our next meeting will be next Tuesday in the morning. Those stakeholder meetings are all being conducted over Zoom. Again, we really wanted to reach the most amount of people that we possibly could and, receive feedback that represents concerns from across the state. So encourage you to register for that. Again, we are holding them monthly, so if you're not able to make the monthly meetings, we'll have all of a summary of the meetings available on our website. And with that, again, kind of pointing you again to our website, and you can sign up to receive email notifications as things progress down the rulemaking process. As far as program implementation, I'm happy to answer any of those questions, or Scott Garnkars and Michaela Snow, who are in our dredge and fill program, can answer those questions as well. And with that, I will open it up to the room to see if anybody has comments or feedback or thoughts you'd like to share.
Questions from the board? Or Ms. Morgan? Well, did you want to make?
Well,
Yeah.
do you want to, or do it after the discussion?
I want to get after the discussion. We just have a question from Director Chavez.
No, I think it's more of a discussion item, sorry.
I'll jump in with a question for Ms. Morgan.
Sure.
You described to us a situation where Sackett Waters would require compensatory mitigation that would be the situation would be outside of a normal 404 permitting.
Sure. So not, for the state, it's really not going to look any different than what it would look under U.S. Army Corps of Engineers. Again, I will maybe just refer back to this slide here, kind of outlines these unavoidable impact thresholds that would trigger a compensatory mitigation requirement. So if your project were to exceed unavoidable impacts above these thresholds, then you would be required to undertake compensatory mitigation, whether that be for streams or wetlands. It really just depends on the type of project that you're undertaking.
Just for clarification, this is for streams or wetlands. I mean, obviously, wetlands are disconnected from navigable way.
Yeah, great question. I think I understand. So kind of are you asking how to distinguish between what is a state water and what is waters of the United States?
What now?
Okay. Yeah, so it's a really great comment and something that we have been really thinking hard about. Unfortunately, there are functional maps or GIS layers that can assist making that determination of what water feature would be subject to federal jurisdiction versus state jurisdiction. So our initial guidance right now is if there's a question about whether or not you're working in waters of the United States versus state waters, is to first consult with the U.S. Army Corps of Engineers and have them provide their input on whether or not that activity would be subject to their jurisdiction. If not, then it becomes subject to the state rules, with the exception of those exemptions and exclusions that we enumerated earlier.
Thank you.
Sure.
Yeah, I have a question. I wonder what kind of feedback you are getting from stakeholder.
Yeah, we've actually received a significant amount of comments and inputs from our stakeholders. I unfortunately don't know how that information is going to be shared out, but all of those comments will be publicly available. The best way, if you're interested right now, I'm sure we'll have some of this more ironed out in our presentation next Tuesday. But I would encourage you to email this CDPHE comments email address, and they'll be happy to kind of point you in the right direction.
Mr. Young.
So does the state have some financial resources coming to implement this program and the rest? And then we're already facing a $700,000, whatever the number, $7 million deficit. And then I read, that the CDPHE can't get some of their permits out right now, and we're backlogged, a bunch on some of these permits that are in there right now. I'm struggling with this, and I said that during our Upper Yampa or Yampa roundtable meeting as well. So, but anyhow, what it is, we appreciate the process. I just want to make sure that if somebody is going to do it right, that you guys are going to be able to implement it and get a turnaround on it.
Yeah, I appreciate that feedback and that input too. We are, based on the number of notifications for projects that we received under Clean Water Policy 17, we do believe that we're poised and we're in a really good position to issuing these temporary authorizations within the time control goals that are outlined in the legislation. I will just kind of make a distinction that there's a difference here between permits that our division issues and these authorizations. They function a little bit differently. So in the traditional permits that you're referring to, where there's a permitting backlog, are managed by a different section. So we're optimistic that with these new resources for our program, that we'll be able to issue these temporary authorizations timely.
Yeah, I'm wondering, along the lines of Director Munger, is this going to be, are you going to hire people to enforce this, or people out in the field, or how is this enforceable?
Yes, and I think that's it is enforceable. We do have, currently we have 2 people on our team that will be issuing temporary authorizations and will also be responsible for doing the compliance oversight on a select amount of projects. So I think that's one advantage to having this program in our compliance and enforcement section. Just to give you kind of a sense of how our section is divided, we do have an entire compliance team. It's made up of 9 full-time folks. They cover the entire state and do compliance work related to construction stormwater activities. So we will have those folks in the field at certain points of time, and they can also observe compliance with these types of projects. Another thing that we attempted to do with these temporary authorizations, which I think is advantageous, was looking at them with the lens of compliance and enforcement, so that not only are the terms and conditions clear for those who are attempting to comply with the authorization, but they're also clear from a compliance and enforcement perspective.
Thank you.
Mhm.
Travis?
Hi, Kelly, it's Sonia Chavis again. Just for the that I did want to highlight some comments that were made by the Upper Gunnison District, and those were that, we've done a lot of work in the Lower Gunnison project and other places on salinity and selenium piping and lining projects. And just so the board knows, those ditch construction activities are not exempt, because the U.S. Army Corps of Engineers and the EPA consider when you put an open ditch, earthen ditch into a pipe, that's a change in use. And it's a little different than the way we think of change of use. So I just wanted to bring that to your attention, and that's an activity that you're carrying out. It'd be really good for you all to make comments on this. And a lot of that activity happens under Regional General Permit number 5. In that permit, it also states that there's a special agreement between the U.S. Bureau of Reclamation and the NRCS on salinity and selenium control projects, such that they have a memorandum of understanding that says that for those projects, they're not required to do pre-construction notification. I think that if that's still important to all, it begs the question, would the state of Colorado have that same type of agreement with these entities on those projects to help streamline them, ensure that they don't get delayed and things like that? I think we also need to make sure that with any compensatory mitigation, we're not increasing consumptive use in any extreme or reach that may already be administered or on call frequently, and that we don't push consumptive use into certain basins through potential wetland banks or projects, that they should probably remain as close as possible to where their point of impact is, but that creates its own set of challenges in terms of finding suitable projects. And then I think the timeline that was brought up, and this is a comment that was made at the Gunnison Basin Roundtable, is that a 2-year timeline for individual authorizations, many people have felt is unacceptable and would like to see a shorter time frame for those. And then just being in a community that practices flood irrigation primarily, I'm a little concerned about determinations about when the state thinks they have jurisdiction over a project or not. And then I also encourage board members to look at the recapture provision in this, because it says that when you're putting a ditch from open earthen pipe into a closed open earthen system into a closed pipe, that project may impair the flow of groundwater, the movement and support of some of the wetlands. And so that recapture provision, I think, we wanted to bring to your attention to look at closely. And I think, Kelly, there will be another opportunity to comment in April.
Correct. Yeah. There will be opportunities following every stakeholder meeting. There will be opportunities to comment, and we can, we'll solicit feedback throughout this process. But thank you, Sonia, for raising those issues. I heard them the other evening, and so I made note of those, and we'll talk about that internally here. So thank you for that.
If Mr. Chairman, if there are no more questions for Ms. Morgan, I do believe that Rebecca Breezemore, on our technical staff, who's been attending all of the stakeholder processes, and in fact is on the steering committee, did want to just provide a couple comments. And Rebecca, apologize for bothering you while you're ill, so thank you for showing up remotely, and thank you more for not being here. So.
Yeah, thanks, Andy, and I apologize for not being there today. Trust me, I would much rather be with you guys than sitting here blowing my nose and sneezing all day. But I just wanted to thank Kelly Morgan for being here and presenting. I know that she and the rest of the Water Quality Control Division team have been doing a really good job about getting out and talking to stakeholders. I've been able to hear their presentation a couple times, and they do a really good job explaining an incredibly tough topic to condense into less than an hour presentation. So really appreciate their time here today. But I just kind of wanted to follow up with a couple pieces of information about the River District's involvement. As you guys know, we have been involved in this process since the very beginning, since it was in the legislature last year. Zane and Jason did a very good job at providing comments for that and being involved in that process. And since then, since that bill was signed, the stakeholder sessions that the Water Quality Control Division kicked off in September, we've been involved in those sessions. And most recently provided comment on the draft regulation. That draft regulation, the comments closed for that, I think, last week. And the River District comments were mostly, I think, centered on fleshing out some of the specifics regarding the general authorization and the individual authorization process. We had some clarifying questions regarding how the public notice would be issued and how that appeals process would go, and just some of those specifics, which I think will be fleshed out more as this is ongoing. And then we had a couple questions regarding time frame, which again, I think will be discussed at length with the remaining stakeholder sessions. I will be continuing to be involved in those stakeholder sessions. As Kelly mentioned, they will continue until the rulemaking hearing in July. And the Water Quality Control Division also set up a steering committee that will develop some of the focus areas for topics of conversation for those sessions. And I was asked to be on that steering committee. So we will continue to be involved, and we're always happy if you guys have comments. I'm always happy to take a phone call or an email from you to hear questions or concerns and bring those to the division. And I know that they would be willing to hear those too.
Great, thank you.
Okay, thank you, Rebecca. I appreciate that. I just wondered if the board had any general discussion on this permitting regimen that's being developed, or thoughts, comments, anything you'd like the staff to do more of. I certainly appreciate Director Chavez's comments, and so anything else.
I'm gonna take a small piece of this thing. And I guess, I think there's gonna be some remorse once this rule gets implemented. As I've seen and I've commented, there are areas that were not completed for comment. And the rules, like for the size of the stream or wetland, for compensatory mitigation, that's mandatory cash you gotta hand over, however you wanna do it. That was not outlined, so we couldn't provide comment on it. Well, that's kind of a big deal if you're looking at 0.03 acres of a stream that's disturbed that now requires to get compensatory mitigation than a 404 permit. That's far more reaching than what the federal 404 permit is today. And I see other areas within this proposed ruling that is more extraneous than the Rapinos rules that you're trying to mimic. There's 404 through the Army Corps was developed for navigable waters for commerce. That was the sole purpose why Army Corps was put in, for like the Mississippi River, the Missouri, or things like that. Colorado has no navigable waters for commerce. That's never been established. So realistically, does Colorado or Army Corps, if they're really challenged, do they have jurisdiction over any of the waterways? Well, if they don't anymore, the state does, and now the state's gonna be the planning and zoning commission for your county on what you can and can't do and how you want to proceed. And you get into the purpose and need, I mean, purpose and need for any federal permit that needs a 404 license is thumbs up or thumbs down. If you don't get the approval on your purpose and need, your project's done. Is that how it's gonna work with this same type program? To where we file a purpose and need statement and the state says you have to refine because they don't agree with it? I see some conflicts there, and I'm not asking for a response there. It's just, this is just things that I think need to be discussed, because that's a very, very early on process that gets done, and Colorado's following that, and that gives the state say on what you can and can't do. I find that very problematic as we go forward with this program. That's just one area. I have a slew of more, and I will.
No, you keep going.
I will wrap up here because I see this as a direct overreach of state government. Direct overreach. And I've been privy to the comments that have submitted by the River District. I have submitted some very harsh, I don't say harsh, direct comments to the state on this. I think the River District, if there is another opportunity to provide comment, I think we need to strengthen those up, and I think we need to get them out there in front and represent our constituents, because I don't think this rule is what people, has this been drawn out, is what the legislator voted on. And I just don't see how this is gonna be of great benefit to the state, other than those that believe in pure preservation of everything. So I'll, thank you.
Mr. Winterby?
You know, I would agree with Van Brink on his deal, and I also agree with Tanya on hers. I think there's unintended consequences on some of this that people didn't really think about. And when you look at those pieces, I wish Tom Gray was here today. Because part of this is gonna come back to haunt you, and exactly when I hear that it's, you gotta buy a credit from a stream bank, right, to somewhere else, and that costs money. But most of those streams are covered by core. So when I see, and pardon the pun, they're muddying the water here, because you're talking about streams which are already covered by core, right? And so to get, and I think that's where Carrie was going with your question, right?
There's two different bodies of water, sure, that we're talking about.
Right, but how you separate those completely out, and you know, like in the Pueblo district in the Army Corps, they had, Florida wasn't getting their EA done. They bogged down, we had a couple of permits that were in the Pueblo district, and this is just kind of a side note. They shoveled 3,000 permits from Florida to other agencies throughout the Corps district, and it bogged down. So you were there, I mean, it took 21 months to get these things through, right? And it's back to Allen. If they don't agree with that, it's just, you're shut off. There's not, you either reapply or keep shoving enough money out there to, and most people can't do it. Most of these companies, and you're absolutely right, Sonia, what you're talking about, these ranch guys, where does the state then become? Because it's a matter of definition. Where are they going to interpret that you're right or wrong? And then it's up to them, and you don't have a say. And where that jurisdiction stops and starts. So that, I agree with, we need another bite at this apple to make a little stiffer what our intention was when we voted on it and supported it, and have some of these things a little bit more ironed out.
Chavez?
One of the recommendations that came up at the roundtable is that we come up with some scenarios, some actual like
Right.
projects that we walk through as a group and kind of go through.
And see what the
What,
pitfalls are.
yeah, just to kind of get comfortable.
totally
and
agree.
We can probably give more constructive consideration, comments back when we have maybe a few of those. I think it would be helpful. And then I think just a study of the different permits, and I think specifically, general permit 5 would be a good exercise for the group.
Jerry?
Yeah, I agree with Sonia. Coming up with a number of scenarios to kind of walk through to see how this will hit the ground, it will be important, and I can see some definition need to be added around that exemption about fringe wetlands that are created by a ditch. That's a common thing that happens across the Gunnison Basin and elsewhere where you've been irrigating and created wetland. I've had to get permits. Gunnison County forced me to get permits to build driveways in some places, in other places they didn't. The Army Corps forced me to do a mitigation plan for a shopping center in Delta for an irrigation ditch that ran through Delta. And and then the next Army Corps guy said, don't worry about it. That might fall under, may or may not fall under the Sackett waters. One other comment real quick, there was one of the few interesting things about CRUA was there was a panel of attorneys that discussed the unintended consequences of having to go to the Supreme Court. And what you may or may not get out of it is a good reminder for us who might be looking at some Supreme Court case on or hearing on the Colorado River that might determine our future, not too dissimilar as the Sackett case where we've asked the court to weigh in on what is the connected water and what is not. And now the states start trying to backfill the protections for wetlands and streams and that the Corps provided at one point. So these things have, ripple effects.
Well,
On that high note.
yeah, on that high note, I want to just ask, I guess what I would suggest is perhaps Rebecca and Jason could come up with some scenarios in which we could present to the board how we think those might work. Excuse me, one problem is the timing of our next meeting, our quarterly meeting in April, and I believe there's another comment period, if I understood you correctly, Kelly, sometime at the end of April. So we'd have to move fairly quickly to assemble comments after the second quarterly meeting. If that's correct. Rebecca, please correct me if I'm wrong too.
The sky is falling.
Perhaps one of our subcommittees could take on assist with that or I wouldn't mind.
I mean, I think you guys could delegate that to the executive committee, but I'm not sure there's another committee that would be appropriate. The Water Supply and Projects Committee is not.
I know. I can't think of one either.
My pleasure.
Okay.
I know.
So.
Can we have a special meeting?
We could tie it into one of our special lunch meetings if you'd like to do that. We do have those. We do have those scheduled, and we'll talk about that tomorrow, but our legislative.
It's important. I do too.
All right, we will target that for a meeting, hopefully in, if Rebecca and Jason, if we could target that for a meeting in February, that way we would have time to provide some comments, so.
Thank you.
Certainly. Thank you for your input. Kelly, thank you for coming. I really appreciate you. Sorry that you weren't able to be here, but we appreciate your efforts nonetheless, so thank you.
Sure. All right. Thank you all. Have a good afternoon.
Thank you.
Okay. Well, we're on to the general manager's report, item number 11. Want to just touch on a few things. The Colorado River interstate and intrastate update. I think just starting out, my memo covers quite a bit of stuff, but I want to just indicate that on the interstate arena, we are seeing continued lack of progress between the discussions among the states about what the post-26 guidelines should be. The states did not meet as they traditionally do, the 7 states at or around the Colorado River Water Users Association Convention in December. They appeared to be unable to even be on the same panel. They had two separate panels, one for the upper basin, one for the lower basin. There was a lot of finger pointing, some dramatic statements by both sides. Very little in the way of demonstrating serious intent to compromise or reach agreements between the parties. All of which is interesting, just because, just to remind everybody on the board that you know, while we all refer to these as post 26 operating guideline negotiations, the reality is the Bureau of Reclamation has the authority, or the Department of Interior has the authority to enact guidelines for the operations of Lakes Powell and Mead. They would prefer the states to reach an agreement, but there's nothing in the law that requires that. And you know, we are transitioning to a new executive branch as of this week. We don't know yet who is going to be nominated for several key positions in the Department of Interior. Assistant Secretary for Water and Science is a position that's traditionally very important to the Colorado River. Bureau of Reclamation Commissioner. We have seen a myriad of names for those positions, but nothing's been announced publicly. The Secretary of Interior nominee, Doug Burgum, the current governor, or just, I guess, recent governor of North Dakota, has begun his confirmation proceedings, but certainly those aren't wrapped up. It appears he's likely to be confirmed by the Senate. But there's going to be some slow walking by the feds just while they assemble the team at the executive branch level and the political team. So we have states that aren't really communicating well. They have, they do, I will just say, I understand that the states are meeting this in the next week or two, and hopefully we'll make some progress. The upper division states, at the request of the outgoing commissioner of the Bureau of Reclamation, did submit a refinement to their original proposal. And if you remember, their proposal had some items in it that directly could be modeled, that were a rule curve as to how Lake Powell would be, the releases out of Lake Powell would be managed based solely upon Lake Powell's contents. Today, they're managed based on Lake Powell and Mead's contents and their balance between the two. The upper basin said, no, it should just be based on Lake Powell. And based on Lake Powell, it means that it's really focused on what the hydrology coming into Lake Powell is. And so that would be managed, the releases out of it would be based on what's anticipated or what is actually coming into it. It makes sense from that perspective. They developed a rule curve, the upper basin states did, that had the bottom end of the releases at 6 million acre feet. Mainly that was the understanding from the upper basin states that was about as low as the federal government was willing to go with annual releases out of the Glen Canyon Dam. Lake Mead was being, releases were then governed by both a combination of Mead and Powell contents. And with an effort to have the lower basin start living within the hydrology, real-time hydrology based on what's in Powell and Mead. The upper basin and the lower basin share a desire to say, well, the first 1.5 million acre foot cuts in the system are going to come out of the lower basin, because that's really an amount roughly equivalent to their system losses, their transit losses, and their evaporative losses. And they're finally going to account for that by reducing their usage. The upper basin's proposal said, hey, unless Powell's 72% full, you're going to cut your uses by 1.5 million, and it's not going to be compensated. The lower basin said, you know, maybe when it's like 40% full, we can still not cut that 1.5, we can take it. And then if we do have to take it, maybe we should get paid for it. So they're very different approaches there. The upper basin said, hey, we may need up to, you know, roughly almost 4 million acre feet in cuts. That's only 1.5 million. So here's a scale under which the lower basin can contribute the remaining up to 4 million acre feet of cuts. The lower basin said, no, you know, we think after that 1.5, we should cut equally. If we have to cut, we cut 1 acre foot, you cut 1 acre foot in the upper basin. Upper Basin correctly pointed out, hey, our states don't have the authority to cut our water users. We're not managed by the federal government up here. We in our state of Colorado, for instance, many of us believe it would require a constitutional amendment that would modify the prior appropriation doctrine. It didn't seem likely that we will approve that. I mean, our voters have shown themselves to be nuts when it comes to constitutional amendments, but I don't think that one is likely to fly within our state. So that's where we were. Back in December, Camille Tootin asked the Commissioner of Bureau of Reclamation at Upper Basin and Lower Basin states, hey, refine your proposals. Give us a little bit more that we can actually model, because we're not planning on modeling either of those proposals because we can't. So the Upper Basin listened and said, oh, well, we have these parallel activities. Among the parallel activities that aren't in the body of the proposal for the Upper Basin is this conserved consumptive use program. Could be system conservation, it could be demand management, it could be some other name, whatever they want to call it. But it's paying water users in the Upper Basin to not consume water and to allegedly send it downriver so that it can help stabilize the system. Upper Basin said, we'll try to engage in that under certain terms and conditions. That's as much as they said in their original proposal. So when they flushed that out, they said, hey, here's what we meant. We'd like 2 accounts in Lake Powell. One is a conservation account that would be filled by 2 different activities. One activity is essentially a conserved consumptive use program in the Upper Basin. And we think maybe we could produce as much as 100,000 acre feet into that, but we can't guarantee it. It's a lot easier for us to do that during wet years than it is during dry years. So under extremely wet conditions, we'll try our best to get you that. And you can try to model our stated commitment to try to do that. You can model that now because it's up to 100,000 acre feet. They also said, oh, but on an annual basis, we want you to figure out a program that we would have to approve that would compensate Upper Basin tribes for their decreed settled water rights that they're not using today. So right now we have in our state 2 tribes that have reserved water rights from their treaty that date back to the date of their treaty. In order to get those things decreed and confirmed, the tribes gave up some of their appropriation dates, moved those around about 20 years ago. But they're not able to use a lot of that water because they don't have the infrastructure to get it to their place of use. They don't have the resources. The Bureau of Indian Affairs and the Department of Interior have never provided those assets or that ability to use the water. So our tribes said, or our states then said, well, if we can get a program like that, let's compensate those tribes for that unused water. Because right now what's happening to it is it's flowing down into Lake Powell, flowing through the Glen Canyon Dam, either flowing down into Lower Basin water users who are using that water, consuming it, or under recent programs, those water users are getting paid not to consume that water. So they're being paid, instead of the tribes that own it, the water users down in the Lower Basin are getting paid to leave it up in Lake Mead so they can use it at some other point in time. So our state said, hey, along with the other Upper Basin states, said, let's up to 100,000 acre feet a year of that conservation pool. So 200,000 acre feet a year are available to create a conservation pool with no cap on the size of that conservation pool. So if it's 200,000 acre feet a year for 5 years, we got 1 million acre feet sitting there. Our old modeling under the risk study says you're going to need 2 to 4 million acre feet a year sitting or total sitting in Lake Powell to make any kind of a difference with compact mitigation or mitigating the risk of a compact retention. So if you could actually store that water there, have it under control of the Upper Basin and use it for compact compliance mitigation, it actually kind of makes sense if you could do that. That's one of the pools. The other pool is something called a protection pool, which is really just, if you remember, under current agreements, there are these things, it's called the Drought Response Operations Agreement. It's the releases out of the upper initial CRISP unit. So it's Flaming Gorge and Blue Mesa for the most part. The Navajo is not capable of releasing much water because of an infrastructure issue. So it's really those two upper basin reservoirs, the majority of which would actually have to come out of Flaming Gorge. That pool is limited to 500,000 acre feet a year, and only under certain circumstances where the infrastructure at the Glen Canyon Dam is at risk. And they would send that water down, and it would sit there and also not be released except for under certain conditions where the lower basin has really reduced its consumptive use and there's still a huge drought, and then it would be released. There are a lot of details. I'm very much trying to summarize it. I do link that 8-page upper basin offer or refinement in the memo. I would suggest it's worth reading. But here's my point, is that the lower basin and the feds have been asking our state and other states in the upper basin to come up with, put meat on the bones of a conserved consumptive use program. And, you know, to date, we've had 2 years of system conservation, the system conservation pilot program. And we saw in those 2 years, every drop of that water that came out of our state came off the west slope. In the first year, it was about 16,000 acre feet of water. This last year was about 39,000 acre feet of water. If the intent is to get 100,000 acre feet of water, and the rules don't change and there aren't proper sideboards and enterprises, all of that water is going to come out of the west slope and out of west slope agriculture. And it's gonna, and I say this, if someone can find money, because that's the second component I want to talk about. But so we've got that going on. Just to point out, system conservation pilot project was authorized for 2 years. It operated in 23 and 24. There was a bill to reauthorize it by Senator Hickenlooper that passed the Senate in December. The companion bill never made it in the House, so it didn't go forward. Our understanding is, even under the current Congress, that system conservation reauthorization is going through, is getting a hearing this week and may move forward with the intent, which I can't quite figure out the logistics, the intent to actually use it in this coming water year. Even though there's no program stood up, there's no application process, there's nobody who's running the program. The UCRC has said they'll be happy to run it and they'll get the information out as soon as they can. But most farmers and ranchers I know plan their crop production in maybe August, maybe October of the year preceding. They might get it authorized at this by February or March. More interesting to me is the only way they were paying for system conservation right now is through the federal government, through the Inflation Reduction Act. There was a provision in the Inflation Reduction Act that sent $125 million to the UCRC to run this program. Well, yesterday, an executive order was signed by President Trump that says no IRA money is allowed to be spent anymore right now until we review it all and understand it. So I don't know how the federal government is going to fund this program if they actually manage to authorize it. I suppose they could authorize new funds. They could make, put that in the legislation. To date, they've been unwilling to modify any kind of language within that reauthorization bill. So it's a quagmire, and one that, if you're looking for certainty as a rancher or a farmer to get paid for your non-use of your water, I wouldn't count on this one, right? So, but what it's all symbolic of is where we're headed. Our state, the federal government, others in the basin really want this program instituted. We know from experience, just common sense, unfortunately, that without a program being developed with rules and structures that you've all talked about before, it's likely that water is going to come out of here, and exponentially more and more each year if we continue to experience these dry years. This board is commissioned, and we have economic studies that show that could be disastrous for our district, for our agriculture in Western Colorado. One of the findings from our economic study that I want to draw attention to, because it really matters who pays for these programs. If the federal government is paying and the money is coming into our district and the money is actually spent on people who live and operate and work within the district, local owners and operators, a very significant portion of that money, 65 to 70% of that money, stays in the district, stays in the West Slope, and generates secondary economic benefit among the other businesses and community within the district. It is as if someone sold their product to a buyer out of the district and the money came in. It's the same concept. Well, the state of Utah has taken the position on conserved consumptive use programs that we can't count on the federal government to pay for these anymore. They've authorized $1 billion to pay for their own demand management program that they're setting up. And they've told the other states, hey, you ought to do the same thing. State of Colorado and the other upper basin states, we can't count on the feds to pay for this. We ought to pay for it. Now, Utah's demand management policy and their program is not designed necessarily to get water into Lake Powell. It's about balancing their own internal water needs. But on an interstate level, Utah is saying this is the way of the future. So go back in time in when Proposition DD was passed. That's a voter approved sports betting tax. That tax, which was just we just enlarged the state's ability to keep the revenue from that tax this past November with Proposition JJ. That tax can be spent on the water plan, right? There are 5 categories of money of areas that tax can be spent on within the water plan. And then there's a final category, which is a conserved consumptive use program. And our district and others on the West Slope lobbied to put language in there that if state money is ever spent, we have to avoid disproportionate harm to any one area, meaning it should be spread out among all water users in the state. Our state go back a little further to 2018 when the CWCB passed its demand management policy statement, said the same thing. You can't implement a program within our state, by our state, that causes disproportionate harm to one region or basin within the state. The UCRC ignored that when they ran the 23 and 24 system conservation pilot programs. We know a larger program is coming from either being paid for by the feds or possibly with state money, although I will give our state credit. They've shown no indication they desire to spend any state funding on this program. And in fact, keep in mind, the state's pretty money short right now, so it's unlikely they're going to stand up a massive program with state funding. But there's a lot of pressure to do this. And the question is, what would you as a board like to direct us as staff and council to engage with in this? We've engaged in the past with not great success. So would look for some guidance from this board on what you'd like us to accomplish on that
one. So I'll lead off here. So all of us up here, and we're all still this is kind of creek, but we still haven't been sold on the bang for the buck, So, and again, I think that's what, and again, we haven't seen any of those studies or whatever, and that's what I hear, and that's what I hear anyhow out there is, so we're gonna be putting aside water. Is there something else that we're missing here? Is there, goodwill or, that we're moving forward and doing something that even entices us to do that? So
I will say this, we have water users in the West Slope who couldn't jump fast enough to get the money to not.
I have some in my county too.
We have lots of them throughout our district, and it's an exercise of a private property right that is being paid for by the federal government, and we've demonstrated both in 23 and 24 and in the earlier system conservation, the irrigators are interested in being paid for not irrigating. There's no question about it. So there is a demand by the irrigators. Your question goes to, does it help the system at all? The work we've done says no. Okay, it really doesn't help. A lot of the system conservation pilot projects that were approved, that water never left the state of Colorado. And some of the projects that were approved under this last year, had it been a different year and there wasn't maintenance going on some of the trans-basin diversions, would have gone not downriver to aid Lake Powell, but it would have gone east on the main stem of the Colorado, and it would have ended up over in northeastern Colorado or potentially the Pueblo area. So we aren't convinced at all as your staff that this is a program that's worthwhile. Now, in the negotiations on the 7 states, going back to that discussion, there's been some indications from members of the lower basin negotiating team that if the upper basin would just give and agree that it would participate in a conserved consumptive use program, that could be enough to get these negotiations off of their deadlock and actually reach an agreement. So there's some incentive. It's a wishy-washy political thing. You look at the volumes of water that are needed to bring the system into balance. And as I think Director Catlin has pointed out, you could dry up the entire Uncompahgre system, our biggest single irrigation system in western Colorado, and it might give you water for about a week and a half down at IID. At tremendous economic cost to the Montrose Delta area. So that's the reality. But this is the thing. I don't think that we're in a position to say this isn't going to happen, go away, because this is a something that has a lot of momentum behind it. Our state and the other 3 upper basin states have put it on the table as a negotiating chip. We will see some form of program come out of this. The question is, when it gets operated inside of our state, can we influence how it gets operated? Can we create a situation where we avoid every drop of that water coming out of the West Slope? For instance, just by way of example, City of Pueblo and the Pueblo Waterworks offered to participate in this year's system conservation with the ditch they have in the Eagle River system. And they said, hey, we'll leave the water in the system if we can get paid, but we need to get paid $80 more an acre foot than what you're offering UCRC, because that's what it's worth to us on the other side of the divide, which is not much more, right? $80, that's still significantly less than, for instance, irrigators in the Imperial Irrigation District got paid for that same drop of water because it had made it that far down there and they left it in mead. So Pueblo said, we'll participate. We just need $80 more than what you're offering. The Bureau of Reclamation told the UCRC, we will not approve that project because it's not within our price range. That's the kind of guideline, if you remember, that this board endorsed, which is variable pricing based on the place of use, so you can compete in those marketplaces to get the water produced out and down the river. And that's really an example of where our guidelines, had they actually had them and implemented them, would have worked for Pueblo to participate, and all of the water wouldn't have necessarily been, well, it wouldn't have been West Slope users' water, it would still be West Slope Colorado River water.
Is it time or possible to reissue those proposed guidelines that we had that didn't get accepted? And maybe we put a new cover page on them and update anything and say, here's, because I mean, that dangers are like you just said, or like the lower basin getting paid to not use upper basin water that the tribes didn't get paid. I mean, that's
I think we
ridiculous.
could dust off those guidelines. I think we've learned quite a bit since we created those guidelines, so we'd want to modify them and then recommend them to the state and others. There's some work to be done on those, because I do think, at least I feel like our staff have learned a bit since we issued them. We might want to start that process, but engage in a dialogue of some sort with the state and the UCRC.
Andy, I'd make a recommendation that the board directs staff to write a letter to the state and our congressional delegation and put forth some creative ideas on how to conserve consumptive use that avoids disproportionate impacts to the Western Slope could be put forth or considered.
Jerry?
I still have a hard time thinking how we're gonna create a program that doesn't have a disproportionate effect, but short of that, I think we need to point out the fact that there's also more benefits in conserving water to the state. If you were to conserve it higher in the system or you conserve it in the right system, where we can't just look at these types of programs as something that would benefit us past the state line. That being said, as Mr. Ronger pointed out, what are the benefits? That's what I still have a hard time figuring out is, or maybe that's a question we need to be asking is once that water gets to Powell, or what are the assurances that we have that we receive the benefit of that, or it's not something that is just being used by the lower basin right now. I mean, we've been doing system conservation pilot projects since 2017, I believe, and I don't doubt that the ones that I did, that water made it to the state line just because of where it wasn't, but I would also like to know if we do it in the future, that water remains in our control or benefits us after it hits Lake Powell. That's kind of my two big concerns is how do we answer the inequity problem by showing and maximizing more benefits through the system and therefore have a different price point for certain waters. But also once it gets there, what does it do for us? That's my bigger concern.
I would say to the credit of the UCRC and our state Director Dennison that we are, they have reopened the discussion about not just having system water being created by these programs, but having water go into this conservation pool for the benefit of the upper basin to be used later to make sure we can meet our compact obligations. And that water wouldn't be released unless there are really significant cuts that have been made in water consumption in the lower basin. There's no guarantee right now because that's just an idea that's been.
Exactly. That's
Right,
my point.
right. And so I think it would have to be tied into the discussion, like our state will participate in these programs on these conditions, right? That there's a pool in Powell that's controlled in this way. There's a very big desire among our state and some of the other states in the upper basin to make sure that water is used for the collective benefit of the entire upper basin, right? It's a collective obligation to meet our compact obligations. There are some in the upper basin who look at the ICS model that goes on down in the lower basin where it's individual water user accounts. And there are some in our state who would like to see those individual accounts get set up. So not so that they can prevent or be used proactively to mitigate a compact curtailment, but they want to be able to use that water to protect themselves once there's a curtailment. So they would have a credit account. And if you have lots of money and say you're an urban water provider in the Front Range and you can charge your water users a little surcharge for Colorado River funds like this, you could buy that water and from the West Slope, you could send it down, put it in an account and you could protect your interests, right? And that's not something we would be supportive of. So that's the kind of guidelines we want to see come out of the state, out of our state for conditions on participation in a program like that.
We've got a motion on the floor. Can you restate that?
Yes, my motion is,
Sorry, just to clarify, great discussion points from Carrie and Andy, but I think we need to know whether there's a second on the motion.
So restate it.
I'd like to ask that the board direct staff to write a letter to the state, the CWCB and our congressional delegation, that they're ready to put forth creative ideas on how to create a conserved consumptive use program that avoids disproportionate impacts to West Slope water users.
Okay.
And allows us to account for the conserved water.
Friendly amendment.
And allows us to account for that water.
And Ms. Chandler seconds. All those in favor?
Aye.
Those opposed?
Nay.
So noted.
If I may follow up with a response. It's not the motion, it's the concept of going forward by proposing a CCP program. I don't want to be the leadership sending them down a pathway to where this is what's acceptable to us. They need to propose something to us, and maybe I'm off on the negotiations here. But I also see that there's a problem with consequences that's not being considered from anybody. One basin that's extremely heavy in the program, all of a sudden maybe without. Because there's nothing there to. If you short your system, the return flows are gone. That's one piece that I see. But now you're mandated to send it down, drying up a whole lot more. There's unintended consequences that's not being done. And I think it's being driven by panic.
There's a couple of things I'd like to say. A lot of these consumptive use programs don't really look at any other ground besides that's tillable. You know, pretty hard for high mountain pastures to cut irrigation. You guys as high country meadows, same thing. So it puts the focus on the individuals that are row cropping in the lower territories, the Uncompahgre, the Grand Valley. And you know, really, guys, there's not enough ground there to make a dent. If we decided we're not going to irrigate it at all. When it gets to the sacrifice zone, it doubles up because there's not enough ground on this side of the mountain to really do what we're talking about doing. And until the Trans Mountain diverters are included in this, it won't work for us, I don't think. It worries me that the Platte River will tell you we are the #1 ag outfit in the state. And they have more representation than any other river in the state. They're not talking about this at all. But you and my neighbors are talking about this, and that makes us the target. We need to be able to say, listen, we don't want to talk about this until you guys decide that you're part of the state of Colorado too. Because if they don't think they're part of the state of Colorado on the Colorado River, we can't do it to protect them. There's not enough of us. And it just seems to me like it's getting carried on down the road that, and I appreciate what Alden is saying. We don't want to be the ones to kick it off and say, yeah, we'll look at it until we have a conversation with some of these people that are benefiting from Colorado River water right now with no responsibility to the rest of the state of Colorado. That it's up to us to protect them and up to us to protect the state of Colorado when it comes down to the big lakes. We can't do it. There's not enough of us. There's not enough ground. There's not enough water. Kerry?
Yeah, I think you're spot on, Director Catlin, President Catlin. The fact that water, you know, is gonna draw a bigger economic number and they're gonna ask more money. That's not fair for us to just create a system that only has one price point. But the avenue into that discussion is what are the benefits of that water remaining on this side of the hill? You know, it's probably much greater than reducing diversions at the Grand Valley or something else. Yeah, that farm grounds work the same as it is in Weld County, but if we can transfer that water all the way to the system, we're maximizing the benefit within the state. Therefore, whatever entity that's paying for it, and we still don't know that yet, is a problem. Or if there's even gonna be money to stand up a project in 2025, we need to be thinking about that, about what the benefit is to the state of Colorado as a whole, where that water goes and how we get it to, whether it's Blue Mesa or Lake Powell.
Scott?
No, well, we just passed that motion, so it seems the way, I think your point's well taken, Alden. But maybe the way the letter's drafted, we go out. So drafting the letters, we've already decided that's what we're gonna do. We should be careful with drafting it, and put some rulers in there. See if we can fill them out, you know, kind of reverse engineering on who starts it. And include some of what Carrie said, or what Mark said.
I appreciate all the direction, and I do think it's important to be proactive here and engage with the state, the UCRC. Our federal delegation is also interested in this. You know, Hickenlooper has sponsored the system conservation and continues to ask for participation in these kind of programs. I think it's important that we communicate with them. I do think it's incumbent upon us to be proactive in recommending market structures that might work, because we're the ones looking for protection. The UCRC and unfortunately our state, and the pressure of getting the system conservation pilot program operated, didn't step up with any kind of a market structure that would actually benefit or protect the West Slope. And so sitting back and saying, you go first, they did. They went first. They don't want any room. So that to me is not a protective strategy for our water. I think we need to get people engaged in a conversation and on the same page on these rules. That's my thought.
I have one more piece, and I swear, I'll take the time out. You gonna swear?
Okay, let's hear it.
Not now. I'll wait for a little bit. Thanks, Doug. You know, it seems like we gotta give again. And I'm talking from a county that gave it all. Three coal mines down and a power plant going away. We're a tier 1 transition county, along with Moffett County, Routt County, and I think Montrose County is a tier 1 or tier. I'm sorry, I'm not familiar with that. I'm sorry, but anyway. And we're being told we've got to do ag, and we're told we got to do recreation. That's the acceptable thing. And now we're going forward to promote ag. We're even being funded by the state to develop new ag and new water for new ag in our county. And now we got on this side here saying, well, you may have to dry up your ag. These people need to talk and figure out what the hell they want to do, because this indecision and running in a circle is gonna cost people jobs, hospitals, schools. That is very real. Where else are we supposed to cut and get short? Where else?
Agreed.
And I'm feeling like I'm feeling pretty perturbed, backed into a corner. And I know that's the sentiment of my county commissioners as well, to where they're getting downright irritated. Because every time that comes at us, we got to give up more and we got to lose more so that somebody else, east and west, can live fatter and larger while we just dry up and go away, because they don't have to deal with us.
I hear it.
Dadgummit, I'm frustrated with that. There's my swear word.
There you go.
Acceptable.
It's all right.
So if I can, I hear you. We've got direction between Peter and I and other staff members. We will weave a letter appropriately. I want to end on maybe a happier note, and that's Shoshone, and for the evening anyway. I think you've all read, we had some brief offline discussions earlier. Look, our staff put together at your direction an application for $40 million to the Bureau of Reclamation under their B2E funding opportunity. We submitted a 644-page application that had more data and more support and more evidence of what benefit Shoshone brings, not just to the Colorado River in our state, but to the entire system. It was an incredible lift by the staff. I want to just call out Amy Moyer, Brendan Langenhausen, and Bruce Walters for taking the lead on a team that included almost your entire staff. And we were successful. We, on Friday, heard that the Department of Interior is awarding us $40 million. It's out of the IRA. There's current hold as of yesterday on that IRA funding from the current incoming administration. We believe that Shoshone is a project that is bipartisan, nonpartisan, that has support throughout the Colorado River Basin. It is a really impressive effort. Senator Catlin and his colleagues at the House signed an incredibly bipartisan and, just point out, across the divide letter from a huge number of the House and Senate to support our federal ask. We had the support of our federal delegation. We had the support of our governor. I think that we will continue and we will work very hard with the incoming administration and Congress to preserve this funding. We think that we have a good shot at it. But I want to really maybe sit for a minute and recognize how amazing it is that our staff, when we started this last December, so just a little over 12 months ago, we didn't have any money, right? You guys agreed we'd put 20 million of our own funds into it. We now have $96 million committed to this project. That's the biggest lift this district's ever engaged in. And it's incredible. We still have, Amy and I have a meeting with Breckenridge. We have some other towns along the main stem that are interested in helping. We will continue to raise funds. We're not done by any means. We have several steps, the in-stream flow agreement, the change case, the PUC, all of that's coming up and all of that will require all hands on deck. But this is an incredibly great, wonderful, amazing hurdle that we've crossed. And one that, by the way, all sorts of people told us we couldn't ever do. And so thank you for your support and thank you to the staff.
Yeah, well done.
Thank you to the staff.
Yeah, Mr. President, I just wanted to weigh in. I was fortunate enough to go on a lobbying trip with Andy and Zane and Amy Merritt Linky from Grand County and Matt Rice from American Rivers to try and get this funding. And across the board, from our congressional delegation, the Bureau Rec, the USDA, anyone who'd seen this application was just blown away by it. It was so well done, so complete, so on point, and such an incredibly important project that was supported so strongly across the district. So made me really proud of the River District staffs.
While you're on that, I'd like to say thank you for the 2 years of leadership that you gave us. It all came about under your leadership. And I think you deserve a great hand from all of us. Little but mighty.
In addition to the staff, thank you to your different board members, whether it's Glenwood Springs or over there in Eagle, Kathy, and the amounts and the different communities. I don't know how many times you and your team visit Mason County, visiting with the smallest, even Jason Colby, but a lot of the board members put words to the right commissioners of city council people. And so your board, it's a lot of credit that, and being able to have that first 60%, that burden sharing going to the feds and saying, look, we've got this. And look who's participating. Helped us kind of leapfrog into the 40 million. So there's a lot of thanks to go around to everybody. And
Director McGinnis, I would absolutely agree with you that all of our directors were very helpful on the main stem in getting us in front of their county commissions, in front of their towns and councils and irrigation companies. Scott himself spent a lot of time in irrigation district meetings and water user meetings and the city of Grand Junction City Council meeting and
this is about the budget board.
yeah, no, but every, you know, it was a huge lift. It is going to remain to be a huge lift along the way. Gary, don't worry, you're going to be carrying your share up here. But it's a really impressive effort by a district that just a few years ago could never imagine pulling this off. So it's great.
There's a different level of effort put into this too than anything I've ever seen on this, from the River District, at least within my 12, 11 years, whatever it is. But I think it's a demonstration of what the River District's capable of. So we'll expect a repeat.
Yeah, what are you gonna do next?
But realistically,
What are you gonna do next?
it shows and it aligns with our mission that we were talking about in our strategic plan that the district has capabilities to get things done in say, a 5-year plan. And I'd like to see us pick on something else. One, I know you got a ways to go, but when you're getting close to the end with this one, because I think there's more to come from the Shoshone. I don't think this is it. Even when you get it done and finished, there's other thoughts that are to come from that project, a benefit to the Western Slope and potentially even the state. I believe there's more to come. Stay tuned.
Anything left to do this evening?
Okay. My recommendation to the board would be that we call it tonight. We can start tomorrow morning with the hydrology report. I believe Don and Sam are gonna pinch hit for that one. So if we'll do that tomorrow at 8:30. Information and Outreach Committee meeting at 7:30. Anybody confused about who's on that committee? Yeah. All right. Well, thank you. And the president will be there because they come to all of the committee meetings. Thank you.
You have to buy the coffee.
Except I'm on the
She's on the committee.